Did you form an opinion as to whether the defendant was under the influence?
Yes, I felt Mr. Woods was under the influence.
This police officer was pretty much confident on the stand, but he didn't know that he would soon be put in his place by the judge.
On May 18, 2018, DUI criminal defense attorney Larry Foreman cross-examined a confident cop on the stand and completely stunned him and everyone else in the courtroom. In fact, the cop's police report got taken away on the stand. Watch the video to the end to know what happens to these DUI charges.
I'm sorry, in part of DUI detection, what are some of the first steps of DUI detection that you learned in your training?
The very first step is obviously the driving of the suspect, your initial contact with the suspect, and then from there you make the determination whether or not field sobriety tests need to be administered, and then you administer those field sobriety tests. After those tests, you determine whether or not to arrest the subject and offer a breath or blood test to the suspect.
Okay. And now getting back to the field sobriety tests, what was the first one you mentioned?
This officer's name is Keith Addison, who arrested a man, Mr. Woods, for DUI. However, the cop did not have conclusive evidence for his act, and Mr. Woods' attorney would certainly take advantage of that.
Horizontal gaze nystagmus test.
Okay, and so what does that entail?
It is a test of your eyes. It's an horizontal nystagmus is an involuntary jerking of the eyes.
What causes that nystagmus?
Alcohol can cause nystagmus.
Okay. And so I'm sorry to interrupt. Continue.
Based on my training, they teach us to look at the pupil size to make sure the pupils are potentially the same size.
If they're not the same size, what is that indicative of?
That could be a medical issue.
Okay.
Mr. Woods' attorney then took a more direct and attacking approach.
Now, how many stops have you performed for suspicion of a DUI?
Hundreds.
And how many of those resulted in arrests?
Hundreds. I can't give you an exact number.
Okay. So you have a vast experience of doing DUI arrest and detection, and
I've been doing it for a while.
Okay. Now, were you on duty on January 7th, 2017?
Yes, sir.
Around maybe 10 o'clock that night?
Yes.
Okay.
I think it was closer to 11, but yes.
Okay. Did you observe anything out of the ordinary around that time?
Yes, I was traveling east. I was just on patrol. I can't remember if I had left a call or had conducted another traffic stop. I'm not sure. But I was traveling east on 150 heading towards Stanford, not very far out of the city limits. And a white Mercedes, I was doing the speed limit 55 miles an hour, and a white Mercedes passenger car passed me in the fast lane and then abruptly moved over into my lane, what I would consider cutting me off. Came very close to the front of my vehicle. At that point, the vehicle continued on.
You must pay attention to what the officer said next, because it would be a very important piece of information which would be addressed later on by the defendant's attorney.
I don't have a radar in my car, so I matched speeds with the vehicle in front of me. My speedometer read 65 miles an hour. I initiated a traffic stop. Mr. Woods was the operator of the vehicle. I did observe an odor of alcoholic beverages from the vehicle. I did ask Mr. Woods if he had had anything to drink, and I think he stated 3 to 4 beers, that they had just left a Mexican restaurant.
I'm sorry, did you say that he stated they just left the Mexican restaurant?
I think that's what he stated, yes.
All right, continue.
At that point, I had Mr. Woods step out of the vehicle. I asked him to perform field sobriety test.
Specifically, keep in mind the part where he said he could smell the odor of alcoholic beverages.
Because I could observe the odor of alcohol on his breath even after he exited the vehicle. Mr. Woods really was not very cooperative at first and actually didn't want to take any test. At that point, I explained to Mr. Woods that that was the only way I could to determine whether or not he was safe to be on the roadway. That's how I needed to determine whether or not he could continue on operating the vehicle. Mr. Woods did performed the horizontal gaze nystagmus test for me, where he exhibited all 6 clues. At that point, I asked him to take the. Your Honor, may we approach?
He probably refused to take the sobriety test because he wouldn't want to stand in the cold, and he wanted to be taken to jail so he wouldn't freeze to death.
Yeah.
Deputy, do you have your citation with you?
I do.
May I have the citation, please?
Yes, sir.
Thank you. All right, so you had the defendant step out of the vehicle, and he performed the HGN test. Is that where we're left off?
Yes, at that point, after the horizontal gaze nystagmus test, I asked Mr. Woods to perform the walk and turn test, and Mr. Woods stated that there was no need to perform those.
Okay. Now, I've heard testimony that it may have been cold today, but what was your indication from him making that statement?
The attorney then questioned the certification status of the officer, hoping to perhaps get a loose end from there.
So, and just a real quick question back, do you have to recertify for your training, or do you go through a training every so often for DUI detection?
Every 2 years we have to recertify on the intoxilizer, which is the actual instrument that collects the breath and gives the readout for the breath test. As a law enforcement officer, we have to take 40 hours a year just in law enforcement basics, different courses every year that we're a law enforcement officer.
So, based on your 16 years experience, your 40 hours of training, did you form an opinion as to whether the defendant was under the influence?
Yes, I felt Mr. Woods was under the influence. Obviously, that's why he was placed under arrest.
Okay. I have no further questions at this time.
Oh, yes. Mr. Former Cross, when you're ready.
Thank you, Your Honor. I might just have one moment.
You may, sir.
You could see from the officer's face the attorney was asking the right questions. He was clearly tensed up and worried.
You have indicated that you've been doing this quite a while, 16 years, is that right?
I feel like that's a substantial amount of time, yes.
I would agree. That's a long time to be doing something like this. So you've been trained, you said recertified. You went to Richmond 16 years ago, I presume?
Correct.
And there you were given, was it, you said a 22-week course at the time?
Yes, sir.
I think they've since changed that. I think it's a little bit longer now, but...
I think it's went longer and then went shorter, and there was some Homeland Security issues that we had to go through, and I think that's why the course actually went longer.
Right. In your training, do you remember being taught to write your reports and make them as complete and as accurate as possible?
That's correct.
And they taught you that because in the future a jury may rely on it, right?
The officer needlessly overcomplicated the answer to the attorney, asking whether the reports would be relied upon. Of course it would. They have to be accurate for a reason.
A judge would rely on it, wouldn't a judge rely on that as well?
I would assume I don't perform judge duties.
Mr. Johnson would rely on this report?
Yes, I believe you would.
I would rely on this report?
I guess you would.
So you made sure that this report is complete, accurate, and is not missing any information?
Yes, we do the best we can. My penmanship is not the greatest, I have to admit. It never has been. There's a limited amount of space that you can write in the reports. I do the best that I can to get all the information. I try to put the pertinent information to the case in the citation. Sometimes you cannot put everything in there.
Is it so hard to use a second page to continue the report?
I just don't have enough room to put it in there, but I do try to get as much information in there as I possibly can.
So you never pick up a second page and supplement it if there's not enough room in the citation itself?
No, sir, I do not have an MDT which would allow me to do that. I have to do paper citation still, so that makes it very difficult. But no,
so you cannot even supplement it if you have relevant information that must go into that report. You just ran out of room. You're just SOL?
If it must go in the report, it goes in the report.
Fair enough. So I want to dive in. I'm sorry. Let's back up. So
That was a very stupid answer. The officer could just rule out whatever he wished and call it unimportant.
when you were in the right-hand lane on highway, which one was it? 150?
US 150 bypass.
US 150 bypass.
It has several numbers. I think it's 127, 150. I think it's listed as several highways, but yes.
You may be right. I think that's the one that I actually took over. My GPS was.
Yeah, there are several roads.
Right. And you saw Mr. Woods pass you, which you later determined was by pacing him, at least.
Correct.
10 miles over the speed limit.
That's correct.
Okay. And you decided to initiate a traffic stop. Based on that.
Actually, I was going to initiate the traffic stop based on when he passed me and moved over into my lane. At that point, I was already planning on initiating a traffic stop at that point, but then I went ahead and he continued on, so I paced him and paced his vehicle.
When he cut you off, that you made the determination, I'm going to pull that vehicle over.
There was going to be a traffic stop conducted on that vehicle, yes.
And then subsequently you paced him at 65 miles an hour
Correct.
in a 55 mile zone.
That's correct.
And you pulled him over.
That's correct.
And he pulled over, did he continue on for a short while, a long while, or did he pull over right away when he saw your cherries?
I don't remember
Do you
that.
remember?
I'm assuming he pulled over fairly quickly.
This wouldn't be the only instance he couldn't remember stuff. It would be a recurring problem, which I doubt was true.
If he would have continued to drive, I would have listed that in the citation.
And did he pull over to the side of the road?
He did pull over to the side of the road, yes.
And you pulled up behind him?
Yes.
Okay. Shortly after that, do you remember approaching Mr. Wood's vehicle?
Yes.
Was his window rolled down, or did you ask him to roll the window down?
I have no idea.
You don't remember?
I do not remember that.
But you've stated that you detected the odor of alcohol coming from the vehicle.
Yes.
How can he detect the odor of alcohol coming from the vehicle if the windows were closed? He was clearly lying.
And did you ask him out of the vehicle immediately right then, or did you go back to the car, radio for backup? What procedure did you follow?
Actually, I don't remember. Normally, if I observe an odor of alcoholic beverages, I'll ask the subject to exit the vehicle at that point. I don't remember in that case. I know that you said that I walked back and got back into my vehicle. I don't remember doing that, but I'm sure that's a possibility that I did that to check his license and run his license, but I don't recall doing that. But normally, if I smell alcoholic beverages, I will get the subject out.
He just dismissed any question he didn't want to answer by saying he didn't remember.
Try to perform field sobriety test.
And that's exactly what you did in this case, correct? You asked him out of the vehicle?
Yes.
You stated that eventually you got Mr. Woods to perform the HGN, also known as the horizontal gaze nystagmus test.
That's correct.
And I remember, because I wrote it down, on direct, you've stated, quote, alcohol can cause nystagmus, right?
That's correct.
And there are other causes of nystagmus as well. Do you remember being taught at the academy?
I'm not a medical doctor, and I do remember that, and I think there are some other drugs, PCP being one, inhalants being one, and if I'm not mistaken, a brain stem injury or something to that effect could cause nystagmus.
Are you aware that heredity or diet can also create nystagmus?
Never heard that.
What about caffeine?
I know that there had been some research done on caffeine, and I think that was, if I'm not mistaken, I remember them saying that they didn't believe that affected nystagmus.
The corrupt officer was creating massive trouble for himself, and things were only going to get worse for him.
Let's go back to the when you asked Mr. Woods out of the vehicle. Okay. You've also been taught to look for other indicators of intoxication. You remember the pre-exit, the post-exit. Field sobriety is just one of them. But using your common sense, I believe, we're not leaving common sense at the door, as we've stated. Neither do you. You use your common sense to see, is the subject impaired by alcohol, something else, or if they're just having a medical issue, if it was like a post-accident, let's say, and you need to call EMT, not something that happened here, or EMS rather.
The attorney continued to give the officer slaps indirectly, and he had no responses to them.
And looking over in your report, one of the indicators that are most common, for instance, are red bloodshot eyes.
That's correct.
And Mr. Woods did not have red bloodshot eyes in this
He
case.
did have bloodshot glossy eyes, yes, sir. He did.
And you never wrote that down in your citation?
I believe it is in my citation, yes, sir. It's, if I'm not mistaken, it's toward the bottom of the citation.
Oh, you are correct, sir. I do apologize. Bloodshot, glassy eyes. And it was 10:54 at night, correct?
That's correct.
Okay. But he did not have a flushed face, did he?
I don't recall him having a flush
Which
face.
is another indicator of an intoxication.
A very rare mistake from the attorney, the only one he'd made up until this point.
He did not have slurred speech, did he?
I don't recall him having slurred speech, no.
So he spoke perfectly fine.
He didn't speak a whole great deal, but what little he did speak, yes.
He had no trouble getting out of his vehicle?
I don't recall him having
He
any
wasn't
trouble.
stumbling or falling over?
I don't recall that, no.
He didn't use the vehicle, sometimes they'll use the vehicle to balance themselves as they're about to fall. He didn't do that.
No, sir, I would have listed it if he would have.
He didn't fall over into the pavement as he got out of the vehicle.
No, sir.
He didn't throw up.
No, sir.
You've stated that initially he was a little bit uncooperative, but later he began to cooperate.
No, not really. It's hard to explain. He did what I asked him to do, but yet he would not perform field sobriety tests. When I asked him for his license and insurance, he gave them to me. When I asked him to step out of the vehicle, he did so. When I asked him to take field sobriety test, he did not want to take those. At that point, I explained to him that that's the only way I can, you've told me you've had 3 or 4 drinks. I smell alcohol in your breath. He did have the bloodshot glossy eyes. At that point, it's my duty to make sure he's safe to be on the roadway for him, his passenger, and the public.
What this cop didn't tell was that he didn't let the man get his jacket from his car, despite the extremely cold weather. That would be the reason he didn't want to do a field sobriety test.
Based on his driving, I didn't think his judgment was very good, almost cutting me off. I asked him to step out. I explained to him that's the only way I can determine whether or not you're safe to drive. He then took the HDN, the horizontal gaze nystagmus test, but then when I asked to do the other ones, he said there's no need in it and would not perform those tests for me. And then, of course, at the detention center, he would not submit to a breath test.
For your information, the man asked for a blood test, but this evil cop declined his request.
Was he polite with you?
I don't know if I would call it polite. He was...
Agitated?
No, he wasn't agitated. He was just matter of fact. I guess this is the best way that I can...
Fair enough.
He didn't seem threatening, but he just was not cooperative either.
Do you remember, I know it's been a long time, as a matter of fact, I'm going to ask this question before I ask my next one. 16 years ago, you did complete the 40 hours, which is standard in Richmond to this day, to complete for the standardized field sobriety and DUI detection training.
That's correct.
Well, the officer, if he had half a brain, would know the man would be at least a little pissed if he got pulled over in the middle of a freezing night, having to be outside without a jacket.
Did you ever recertify at any point? Did you recomplete A-RIDE, which is the Advanced Roadside and Driving Education?
I have had the advanced DUI course. I don't know when. It's been years ago that I have had the advanced DUI training course. I have completed parts of the 40-hour course again. Maybe the whole course, I'm not sure, on the field sobriety test.
Do you remember when that was? I'm just trying to get a feel.
It's been years. It's
Okay.
been several years.
Do you remember during the course and the re-course, you were taught, because I've taken the course myself in Georgia with a DRE certified, he's got all the credentials, he's a DRE At the jail, you did not perform or ask Mr. Woods to perform any field sobriety testing?
No, sir, that's not standardly what we do. We normally do it, we make our determination on the scene.
And you've, I think I'm repeating Mr. Johnson here, you've stated in one of his questions, Mr. Woods never asked for you to repeat the implied consent?
Not that I recall.
He could have done the field sobriety test at the station and made an exception due to the weather. But of course he wasn't going to. He wanted to arrest the man.
Prior to asking him to submit to the breath test, which he refused. And then you've also stated that it appeared to you that he understood everything.
He didn't ask me. As far as I remember, if he would have asked something, I would have listed it in the report, but obviously he didn't ask anything, so.
This is a spectacular performance from the attorney, a masterclass in defeating the evil at their own game.
Mr. Johnson, I'll give you a moment and any redirect.
Yes, sir. Just real briefly. So, was there ever any mention of any medical conditions that would preclude Mr. Woods from taking any of these tests?
As far as I can remember, Mr. Woods never said anything about a medical condition.
And is it your standard? Would you say, you know what, it's too cold or it's too hot, or I'm just going to pick you up and take you to jail, and then we'll do the test there?
Normally, we try not to arrest someone unless there's a reason to arrest them. I get that the weather's, sometimes it's hot, sometimes it's cold, sometimes it's icy. We do the best we can with what we have.
It wouldn't be that much of an inconvenience to take him to the station for the test. Either he was lazy or he did it on purpose.
We try to take the weather into consideration. We're cold, they're cold, we understand that, but that's, unfortunately, if we feel that there's a need to perform these tests, we're going to administer those tests.
Now, you stated that, well, you don't recall whether he had a flushed face, but could a flushed face also be due to the cold?
I'm sure it could. My face has been red and windburned before. Okay.
If you did try to consider the weather, you wouldn't have told him to do the test without a jacket and on the roadside.
Now, if Mr. Woods had submitted to the intoxilizer and blown well below the legal limit, what would you do at that point?
His charge would have been amended, as far as I know, to a reckless driving.
Okay. I have no further questions.
Just one, Your Honor, if I may. I apologize.
Take your time. You're fine.
During your interaction with Mr. Woods after you placed him in the cruiser, do you recall at any point Mr. Woods asking you to take him to the hospital for a blood test?
I do not recall
You don't
that.
recall? That's all I have to do.
Mr. Johnson, any redirect?
No, sir.
Deputy, you may step down, sir.
Thank you.
As a result of the attorney's efforts, the defendant was deemed guilty but didn't have to serve jail time, and his license wasn't even suspended. The outcome was much better for them than their initial offer.
Moving on, here's another instance where a corrupt cop was taken to the cleaners by an honest judge. In June 2023, Sheriff Jamie Knoll of Clark County was arrested for misusing state funds and stealing over $5 million from taxpayers' money. He was charged with 31 felonies, and his wife and daughter were also convicted alongside him, as they had been using the money to buy luxurious cars, watches, jewelry, and even a private jet.
2018 and December the 31st, 2022, in Clark County, state of Indiana, you, a public servant, that being Sheriff of Clark County, knowingly or intentionally committed an offense in the performance of your official duties, that being goes to employment as Sheriff of Clark County relating to Brent Fisher. Counts 4 through 15 are all level 6 felonies, which have a range of imprisonment of no time in jail, treated as a misdemeanor, to 2.5 years at the Indiana Department of Corrections.
The sheriff sat listening to every felony against him and didn't seem to care one bit, assuming he is untouchable. However, this time his story had come to an end.
Surrender his passport to you by noon tomorrow, and then you will surrender it to the court by 4 p.m. next Monday, because it's my understanding the court here is closed. Of his choice to Indiana State Police, be it from is appropriate for him to maintain. He will not leave the state of Indiana without permission of the court, and they'll post $75,000 in cash. Mr. Knoll, Mr. Wilder, I know you wanted him released without posting any bond, but it's a unique case, and if you don't like my decision, I'm happy for you to appeal it. It won't be the first time you've appealed me, and the Court of Appeals told you I was right, so I'm happy for you to accept that challenge if you're so pleased. I'm not going to have you report in.
Despite the serious charges, the judge granted bond but made it clear it would only stand if the sheriff followed one strict condition.
You keep one shotgun only. Try to deceive me, you will not like the consequences. Understand? Yes, Your Honor.
Well, as expected, Jamie had multiple weapons in his house, and after the cops raided his home, he was exposed in front of the judge, who was fuming at his entitlement.
Today is that day. You are not the law. You don't interpret the law. You don't enforce the law. You're not above the law. I find that you are in contempt of this court. Take him into custody. No, that's enough. I'll find you guys in contempt for disrupting the proceedings, and you'll be there right there with him.
The judge had every right to be furious, and this was probably the first time Jamie was about to realize the gravity of his crimes.
The question is, I can sentence him up to 180 days without the trial, or I can sentence him to a day, or I can release him. You know what I think the answer is? 60 days in. That's what I think the answer is today.
This sheriff had also appeared on the A&E series 60 Days In, and the judge made a rather pointed reference there, adding insult to injury.
Before he is released, I'll take your suggestion. I want an independent individual to scour that household to determine that there's no further weapons. I find it Mr. Hurdle's original argument that he was trying to make that I sustained, an officer of the law, every time I go into court, I hear, I didn't know it was there, I didn't know it was there, I really didn't. You've heard that a million times. You've heard it a million times, and yet you still take them into custody, would be my guess. Every officer in the world has heard, I didn't know it was there, it's my friends. I'm not buying it. It was your burden, it's your responsibility. And today, the court will enforce that. Take him on.
Just like that, Noel was sentenced to 60 days, but his real trouble was yet to come. His trial soon commenced, and he eventually pleaded guilty to 27 of them, taking a plea deal. But before his sentencing, he had something to say in court.
Mr. Noel, if you would help, you may have a seat and read it.
I'm good. I want to make sure everybody can hear me, Your Honor. They deserve it.
Okay.
Some reasoning that I'm not going to say because I don't want to make it look like I'm trying to deflect blame because it's mine. The reasons of how this was allowed to happen, that's not who I am. It's definitely a big mistake that I've victims that you haven't heard from is my family. And I apologize.
The victims claimed that Noel's mismanagement would continue to scar their families for years to come, and it was during his sentencing when he finally shed some tears.
I asked my kids to forgive me, not being honest with them about where the money was spent or it came from. My dishonesty with them has caused them all great emotional pain and suffering. And my daughter Casey could lose her freedom because of me. It's all my fault. And my family had no knowledge of the business that I was running, or how I was running it, or whether or not I had the right to tell them how they could spend their money or use their credit cards. I controlled everything when it came to our family's finances. They were victims of my deceit just like anybody else. I hope they can forgive me.
Jamie was trying too hard to prove his family's innocence, as they had also been charged. But it's hard to believe they knew nothing, considering they owned 5 luxury homes and 20 classic cars.
Wife, 28 years to forgive me. I understand why she wants to end our marriage. I don't blame her. I violated her trust more than once, and I lied to her. I know this has caused her embarrassment and a lot of heartache and hatred being funneled towards her. I was not honest with her about the money, the credit cards, or her taxes, which I did. I let sin overtake me, and I violated their trust. I'm sorry. I want to apologize to the men and women of law enforcement, fire, and EMS. I spent a lifetime as a law enforcement officer, volunteer fireman, and an EMT. I want to apologize to my friends and colleagues that have been brought into this case because of me. I'm sorry to each and every one of you. I never asked anyone to do anything wrong. I never expected you to do anything wrong, but because of me, you have suffered. I'm sorry for this, and I apologize. I'm Catholic, and I understand the Lord will forgive me, and I hope each one of you can forgive me as well. Judge, I'm going to say just a short prayer, because that's what I need to do. I need to make things right.
After the sheriff's crocodile tears, the judge prepared to deliver the sentence, but first, he had a few choice words for the corrupt sheriff.
I was here last Friday listening to arguments concerning John Miller and the change of venue because of public outrage that the citizens of Clark County have been directly deceived, defrauded, betrayed, ignored, all the while waiting for help. Mr. Knoll, you tarnished the badge you were given by the citizens who you tricked into voting for you and trusting you. You have failed everyone who has ever worn a uniform, whether it be law enforcement, firefighters, EMTs, or the like, to promote democratic freedom. Yet you behaved as a political fascist, thwarting and bullying those who would not submit to your will.
Judge Medlock delivered some well-deserved blows as the sheriff sat silently, listening, but the judge didn't stop there, as he kept humiliating him, reminding him how he had become a complete failure.
We have heard today that real lives were lost in exchange for your greed. Employees lacked equipment and staff to effectively perform their duties, and therefore the citizens of Clark County, and perhaps Floyd County, lost their loved ones. The town of Charleston had to find means to ensure funding for a resource officer for their schools to protect their children, again, because of your greed. You failed as an uncle and a brother in all regard. You failed as a father. I would have thought that any honorable man would have accepted responsibility for their misdeeds instead of getting your daughter arrested and charged. Yet you sat silent until today. Your commitment to your extravagant greed even went so far as to steal from your nieces and nephews, your deceased brother's children. What could be more reprehensible than that?
The judge reluctantly agreed to the plea deal, which would make sure that the cop spends at least 12 years in prison.
Power and pleasure are worth far more than the lives of those entrusted to you for your care. But today, the court says otherwise. Made argument that everybody wants you to do a lifetime in prison. And maybe that's what you deserve, but the law will not allow me to do that. I want you to suffer. And you can understand that, I would hope, considering how you've betrayed everybody that you possibly knew. Everybody that thought you were their friend. Owen could barely look at you. He held you up as a father figure, supported you when you were telling everybody it's a witch hunt. He still believed you. Yet you deceived everybody. With reluctance, I will accept the plea agreement.
Noel is expected to stay a minimum of 10 years in prison, and his wife and daughter still have to go to trial. In addition, he must repay over $5 million to the agencies he defrauded, along with more than $200,000 in fines. Moving on, watch how this judge completely goes off on a tyrant cop.
Then I want you taking him up on perjury.
Your Honor.
Will you take him up for perjury?
He admitted it was a mistake, Your Honor.
No, but he lied. He lied on a sworn
Absolutely
citation.
not, Your Honor, and that is...
In Seminole County, a judge was presiding over the trial of Lisette Gonzalez, arrested for DUI, but he soon discovered that the corrupt officer never conducted a DUI test and had lied in the court documents. Watch as the judge snaps and tears into both the officer and the attorney.
I want to be enlightened.
It was a mistake, admittedly, by Michael Wagner.
I know.
Who testified to that today.
He caused her to have her driver's license suspended for at least a few months for nothing. So are you going to no process that case, or am I going to get mad at you?
Perhaps you can get mad at me, Your Honor, but at this point...
Why wouldn't you? Wait a minute. Did you hear the uncontroverted testimony of this officer?
Your Honor.
Then I want you taking him up on perjury.
Your Honor.
Will you take him up for perjury?
He admitted it was a mistake, Your Honor.
No, but he lied. He lied on a sworn
Absolutely
citation.
not, Your Honor, and that is not true.
I'm dismissing. I am dismissing this charge. No, I'm dismissing the charge. This whole case was fishy, and I have no idea how they. You know what?
Their address on file.
You know what?
The state intends to amend
I'm
the
granting.
charge and proceed on
I'm rescinding the sentence. I'm granting the JOA.
because you don't agree with the state's decision on
I'm
the
granting the
other charge.
JOA in fairness.
In fairness, because you don't like the state's decision today, Your Honor, on the case?
No, you're not. Now that I consider what Officer Wagner testified to and how many times he basically tripped over himself just to arrest this lady with no real probable cause. You're done. Motion, the JOA is granted.
And you're not going to provide a written order on that?
Nope. You want to appeal me? No.
Thank you, Your Honor.
Case should have never been done. Never.
Thank you for letting us know that, Your Honor.
Shockingly, the judge even acquitted the defendant on the spot, leaving the attorney furious. While this judge ruled in favor of the defendant, this next one owned the cops pretty badly.
I'm going to find no probable cause. Mr. Jones, be careful, man.
In Judge Fleischer's courtroom, a man appeared after being arrested during a fishing stop by the police, and it didn't take long for the truth to be exposed.
In official uniforms and riding in a marked patrol vehicle were dispatched to a disturbance at a residence in Harris County, Texas. The officer observed the defendant standing outside the location, being told to leave by the resident, to which the defendant refused by verbally yelling at the resident in a loud, aggressive tone of voice. The defendant a verbal command to put his hands behind his back, and the defendant pulled his hand away. The defendant refused to comply with verbal commands, and the defendant held his arms to his chest as the officer attempted to detain him. He yelled at the officer in an aggressive tone and shouted out loud, "Don't let them take me." The officer performed a leg sweep and continued to struggle handcuffing the defendant due to him pulling away. He continued to give commands, and the defendant continued to refuse.
I get it. But what's he doing? I mean, he's walking away. That's what they wanted.
Before the defense attorney could even respond, the judge made a brilliant observation, explaining why the officer had retaliated with the arrest.
So, Your Honor, in this case, to read the full dim, it was the disturbance call, and they said they observed him standing outside the above location, being told to leave, and they observed him verbally refuse, and then...
Right, but then cops get up there.
And then they observed him begin to walk away, and it says they approached Jones and observed he was intoxicated in a public place based on his slurred speech, pupil size, and...
Didn't say that.
That was in the complete dims, Your Honor. And then it
Do you know
says...
about that?
Yes, Judge,
behavior.
but
Okay,
I
go
have my
ahead.
argument prepared. Judge, my argument is exactly what you started to say. He's coming up and saying, hey, I'm the police. You can walk away from that all day long. My client did walk away from that. My client's loud and emotional, as you can tell here today. You're allowed to walk away emotional, yelling, screaming, even using profanity in this state if you want to. Then the cops come up to him and suddenly there's some kind of unfounded allegation of intoxication. There's absolutely no facts other than that statement. I smell marijuana. You look intoxicated, because it looks like he walked away and the cops didn't want him to walk away.
The attorney raised some excellent points, and by now, it was clear that the arrest was nothing more than an act of ego on the part of the officer.
The argument is based on if he's charged with interference with a public servant, that doesn't come until later. He has to be lawfully arrested and lawfully detained or lawfully with the police before that even occurs.
They go up and they see that he possibly could be intoxicated. So does it go into a potential public intox investigation?
If it does, they need to announce that. You can't just walk up to me and say, I'm the police, stop. We don't live in that kind of society. I'm the police, I need to investigate you, so therefore stop all day long. I'm the police, we're investigating, I need you to step aside, sir, so I can investigate this matter all day long. But hey,
So-
I'm the popo.
The officers had clearly made an unintentional mistake, and everything that followed was the fruit of the poisonous tree. It was now likely that the defendant would walk free.
The reasonable suspicion we have is they begin to investigate what?
So
A criminal trespass.
they're called as a disturbance, and they saw him yelling, being aggressive, and then as he walked away, that's when they saw.
So the trespass investigation ceases because he's leaving. Yes or no?
It's not specified to be a trespass, Your Honor. It's specified just to be a disturbance.
That's what it is. Okay, but it's a trespass that they're investigating a trespass, right? I mean, for all intents and purposes, isn't that what it is? The investigation begins as a trespass investigation because he's there. Homeowners asked him to leave. He's refused to leave, so cops come and he begins to leave. But the cops go up to try to.
Well, in this case, Your Honor, it would be that, yes, he attempted to leave, but once the officers arrived, so they would still need to investigate to determine if a trespass even occurred, to determine,
He's leaving.
He's walking.
He's leaving, right? It's like, here, let me come and mess with you more,
That would only.
right? So it's like adding fuel to a fire.
It's refreshing to see a judge who truly empathizes with the common man and respects the rights of individuals wronged by the police.
Well, they're going up to investigate what they saw him refusing to leave, and he only
leaves.
He only left once they arrived. So with maybe potential fear of apprehension, that's when he decided to leave, which it wouldn't be, it wouldn't undercut their ability to investigate what they had observed happen in front of them regarding that public or that disturbance that they were called about.
Judge, you can't flee a trespass. The way you comply is by fleeing.
Well, we don't know it was a trespass, it was disturbance. We don't always specify the disturbance.
I'm gonna find no probable cause.
You understand?
Mr. Jones, be careful, man. We have enough drama in this life, don't we? You don't like to wear orange, do you? Be careful where you go. Be careful what you do. Everyone's always out to get you, man. Don't let them.
Judge Fleischer did an excellent job dismissing the case. Hopefully, more judges across the country will follow suit to ensure corrupt cops can't keep abusing their power. Well, that brings us to the end of this video. Today, we saw cases where corrupt cops were held accountable by these judges who tore them apart. Thanks for watching. Please support the channel by subscribing and leaving a like. Also, if you enjoyed this video, check out the next video here.